Moving on to 617. 617 is Real Water's motion eliminated to preclude customer complaints and evidence predating the complaint. The court's inclination in this regard is as follows. With regards to, consistent with what the court just said, with regards to 611, to the concept that complaint means lawsuit, litigation, or something there short thereof, okay, then the court is inclined to grant it to the extent it is reference the potential email and others if there's otherwise proper foundation, and also for the notice aspect with regards to, at this juncture, the court's going to say 3, and I'm just giving these an example, I'm not saying they're actually coming in. These are subject to foundation, subject to making sure it's the right Terrible Herbst, who owns it, if they owned it, didn't own it, but I'm just giving as examples the 3 complaints that were asserted to have been made to Real Water in 2014. The court's inclination is the motion would be denied as to those. Those are the ones that have been specifically brought to this court's attention, and so then the court would have to hear about other ones. That's the court's inclination. Counsel for movement, go ahead, please.
Thank you, Your Honor. Joul Odou on behalf of Will Water. Again, I think the trick here, the issue here is that, for example, there's a complaint in 2014 that somebody consumed or purchased a retail bottle of water from a Terrible Herbst gas station in Las Vegas, and there was some type of foreign substance in that. The problem becomes a couple-fold. In addition to hearsay, and they're going to argue it's a business record of Real Water because that's where it was recorded, but it's not reliable. And here's why it's not reliable. There was a number of complaints, and this one included, that couldn't be verified by Real Water. And so we don't know ultimately what was the contaminant. Now, the plaintiffs would like to be able to speculate that the contaminant was hydrazine. There are other explanations as to why the bottle smelled funny. The Real Water folks at the time thought it had to do with the bottling machine and the way that the plastic retail bottles are formed. That was in 2014. For Real Water to now try and defend itself from the investigation performed in 2014 and 15, in addition to the bankruptcy hurdles, becomes very, very difficult. Memories have faded. That type of complaint can be very prejudicial, not just to Terrible Herbst, but to Real Water. You know, again, Real Water has conceded liability as to Myles Hunwardsen, so perhaps there's a limiting instruction that comes in for something like that. Certainly we want to raise that issue, but then plaintiffs argue, well, it goes to notice. Well, it doesn't go to notice. Then they argue, well, it goes to punitive damages. And if the court were to believe or rule that it went to punitive damages, then it should be in phase 2 as to the extent of the punitive damages, if they show some foundation that it's caused by hydrazine. Right now, we don't have an expert saying, oh, well, I have reviewed the complaint of person X in 2014, and in my expert opinion, that was caused by hydrazine. That's a problem for them. We think they've got to have an expert foundation for that. They want to say gasoline smell, color, oh, well, that's hydrazine. They didn't tie that together. Instead, what they did is they had their experts say, well, what would hydrazine smell like? What would hydrazine taste like? It would taste like X, Y, or Z. But the expert never then took the final step, and this is where we think they've got a problem, and said, therefore, in my expert opinion, to a reasonable degree of scientific probability, that was hydrazine in that customer complaint in 2014. Yes, we didn't raise that argument in our reply brief, but it is a foundational issue that exists here, and it is in response to their argument that it goes to notice, which, again, we don't think it does. There's a number of other customer complaints. I could certainly address Tom Pham, Jeffrey Dosatel. Whether they fall in pre or post or whether they're in the other motion, I could save it and talk about them in the other motion. Lois Kessler. Perhaps it's just easier I do it now because it'll be very quick.
that's fine, go ahead.
Tom Pham was a Real Water employee. He recommended to his neighbors that they consume Real Water. His neighbors then, he observed an ambulance coming to their house. Plaintiffs have maintained that we claim that that's hearsay, and it's not hearsay because he observed it. That's not the evidence we're attacking. That's not the basis of our objection. The basis of our objection is the hearsay statements that they went to the hospital because of the consumption of Real Water. He assumes that. We don't have them. We don't have their statements. Perhaps the plaintiffs are going to list them as witnesses in this case. I don't know. But again, that also would not be admissible for other reasons. Let's say, for example, they lay the foundation for the neighbors of Tom Pham. Then the issue becomes whether or not that is what it's being offered for. Again, just like the prior motion, is that being offered for notice? Well, again, Real Water didn't have notice. Tom Pham did. But Real Water wasn't told that they were hospitalized for hydrazine. So we believe that the testimony of Tom Pham as to these issues not only is hearsay, but it's irrelevant. We've conceded that the liver transplant by Myles Hunwardsen was caused by the consumption of Real Water. So there's no purpose to offer that. Tom Pham also has some additional speculative testimony. They would argue it goes to weight. We argue that it actually goes to the foundation. We think he should be excluded. Let me go to the email from Steve Watkins' wife. Steve Watkins is a plaintiff in another case. His wife sent an email. The email says that his doctor told him not to drink alkaline water and something to the effect that Real Water should look into that. Well, many people are told not to consume many things by their doctors. I'm sure mine will tell me don't consume hamburgers anymore. I'm anxiously awaiting to get that instruction. But that doesn't go to that the water was contaminated by hydrazine and Real Water should have done some inspection. Again, what's the purpose of that evidence being offered for? Notice? Well, notice is no longer relevant as to Real Water, and it certainly didn't go to Terrible Herbst, so they don't have notice. So Steve Watkins' email, his testimony in this case should not be permitted, or his wife's testimony, or that email. The next one is Lois Kessler. Ms. Kessler was told by her physicians that she has a fatty liver. The implication becoming, oh, well, it's a liver. People are claiming liver injury. Therefore, we should allow her to testify that she has a liver injury that she believes was caused by Real Water. That violates the Musicato case. There's no reliable evidence that her fatty liver was caused by the consumption of Real Water. They need an expert to tie that one together. The next one that we have is Jeffrey Dosatel. Mr. Dosatel is a very nice gentleman. He's a former Real Water employee, he's former Army. Mr. Dosatel will offer testimony. He's very upset that his dogs died, and he will say they died, he believes, from drinking Real Water. And then on cross-examination, he will admit his dogs were 12 years old and one of them died from drowning in the pool. Again, that bell can't be unrung. We tried to unring it before because that testimony was previously allowed. It's very emotional for jurors to hear that pets died. It's very sad for Mr. Dosatel that his pets died. But in reality, again, there's no tying the pet's death to Real Water. He may believe that they had liver injuries. He may believe that they were injured by Real Water. This may be genuine beliefs of Mr. Dosatel. He gets very emotional about it, and I'm not doubting his veracity. But he also admits that one of the dogs fell in the pool and drowned tragically. And to say that, well, the other dog died at 12 years old because of Real Water is speculation, and it's harmful speculation. It's prejudicial speculation. Lastly, I believe we have a former Real Water customer service person that they want to come in, and they want to have her and Tom Pham speculate as to things that they heard from other Real Water employees. It's hearsay, it doesn't belong, and they don't have any firsthand testimony. This case, regrettably for the plaintiffs, is about hydrazine. Hydrazine caused some very, very serious injuries. Real Water doesn't dispute that. This case is about damages. Nothing could be more prejudicial to go off on these tangents and introduce all this evidence that is irrelevant to hydrazine, to prejudice the jury and get them to award a runaway nuclear verdict. And really, that's why we're seeking to exclude this evidence, because it's not probative as to their injuries. It's not probative as to causation for Miriam Brody, because it's medical causation is the issue. And for those reasons, we believe that our motion to exclude the complaints, whether they're anonymous or whether they're from Jeffrey Dosatel, Lois Kessler, Tom Pham, or any of the other witnesses that they intend to call, because they don't go to any issues remaining in this case. And if they did, there would be a limiting instruction as to Terrible Herbst, but these complaints didn't reach Terrible Herbst. So there's no basis to admit them as to Terrible Herbst. So that's why we believe they should be completely excluded.
And so you're asking the court to address 617, your motion limiting number 9, as well as 618, your motion limiting number 10 together, correct?
I think so. I think that's the best way to do it, because the complaints fall in different time periods when we're looking at different plaintiffs. We know that Miriam Brody was injured in 2018, Myles Hunwardsen's 2019, the other plaintiffs are 2020. So trying to parse them out in that respect becomes a little bit more difficult.
Okay, appreciate it. Thanks so much. We have Terrible Herbst joinder to each of those. So would you like to be heard?
Yes, briefly, Your Honor. Thank you. As to these other customer complaints, as Mr. Odou pointed out, they do not go to notice as to Terrible Herbst. So that's one reason we joined in this. And the second, and I understand there are 3 customer complaints related to chevrons that are still subject of other motions, Your Honor, but even those customer complaints were not provided to Terrible Herbst. And the comment in one of those complaints that they spoke to someone at the retail store, meaning Real Water, it is not only hearsay, but we don't even know who that person was that they supposedly spoke to back in 2014. Second, there's no foundation for any of this. There's no medical testimony tying these alleged complaints or injuries. For example, Mr. Pham's neighbors. There's no foundation for that. Nobody has said, no medical testimony has pointed to the fact that hydrazine caused those neighbors to go to the hospital via ambulance. And that testimony alone is prejudicial, which is the last reason we joined in this. All of these complaints, none of which were made to Terrible Herbst, are going to be designed to show that there were all of these people complaining about Real Water for years and that nobody did anything. And I think it's extremely dangerous and prejudicial to Terrible Herbst in particular, because these complaints were not provided to Terrible Herbst. Thank you, Your Honor.
Okay, appreciate it. Thank you. Counsel, if you wish.
Your Honor, first of all, the Nevada case law says that the prior complaints are admissible as notice of potential defect and potentially dangerous condition. Potential dangerous condition. Potential defect. It doesn't say that some customer had to find the exact defect. And so they keep saying, oh, no customer wrote us a complaint saying there was hydrazine in the water. Of course that didn't happen, Your Honor. But they had notice over and over again of problems with the water. Gasoline-like substance, oil, guy in the hospital for a week. They had this notice. So the issue, I think, becomes, why is that relevant? Okay, that is really the primary issue. And Mr. Odou says, well, we've stipulated liability, so it's not relevant. It's relevant to punitive damages. And we talked about this yesterday with regards to the Terrible Herbst motion for summary judgment. And I started that argument with the case law that says if there's only 1 or 2 complaints, that supports punitive. I want to get into a little deeper on the actual case law. Shane? Now, these are the cases that we talked about yesterday. I didn't talk about them in depth. The Moore case, 1 complaint supports a punitive damages claim. The Day case, 1 prior complaint supports a punitive damages claim. Next page, the White case, 3 in the White case. The Greyhound case, 2 prior instances supported punitive damages claim. The Rodriguez case, they didn't have a number, but they said a number of times that if they have knowledge of prior instances, it supports a punitive damages claim. This Brewer versus Walmart case, 8 prior instances supported a punitive damages claim. And then the Phillips case, they didn't have a number. And actually, I went back and I read this one this morning because I'm always curious at which Nevada judges in federal court comes out with these. And this was actually Judge Robert Jones, who's a very conservative jurist, Your Honor. I don't know if he's really that active anymore, but nice man. But he's very conservative, and he held that didn't have the exact number of complaints, but that supported the punitive damages claim. So what we're talking about in terms of notice is notice of a potential defect that supports a punitive damages claim because did they disregard these prior complaints? And in this case, unlike most cases, we're not just making an argument in the abstract that these complaints were significant, they would have made a difference. We have direct testimony from a former Real Water employee. And Mr. Odou mentioned him, Mr. Desitel, his first name is Jeff Desitel, and he's a former Marine drill sergeant. And Mr. Odou said he got emotional. He actually started crying on the stand. I mean, a former drill sergeant. So, and the reason he started crying on the stand is because we showed him these customer complaints, the 20 customer complaints from Real Water, their written records. And even though he was supposedly the quality control director for a year, he had never even seen them before. Never seen these complaints before. So I asked him, well, Mr. Destel, if you had seen these 20 customer complaints, what would you have done? Shane, can I have his answer, please? Oop, that's a customer complaint. Yeah, this is his testimony from his deposition, Your Honor. If he'd been made aware of these complaints, what would he have done? Would you have done some sort of investigation? He said he would have stopped the production line. He would have stopped the entire production line and figured out what is going on. So if he had been given notice, again, he's there, he's held out. If he had been given notice of this potential danger, this is what he would have done. Now, what more proof of conscious disregard can you have that they had these 20 complaints, and he says if he'd known about them, he would have taken this type of action. So that's why they're all relevant, Your Honor, because first of all, they support the punitive claim in general, but second of all, they support this particular testimony. Now, with regards to the complaints, let's go back to that complaint, Shane. There were admittedly no complaints about hydrazine, all right? But there were complaints about gasoline-like substances. I mean, we have, out of these 20 complaints, we have two, I think, talk about oil. We have 2 talk about gasoline-like substance. We have others saying bad smell. It covers the gamut, Your Honor, but all of them are notice that there's some kind of potential problem or potential in this water. So what should a reasonable manufacturer have done? In our view, what they should have done is they should have paid the $200 and had the complete spectrum test done, which would have included hydrazine. It would have cost $200. So our position is they should have done this at the outset. The product before they put it on the market. But certainly when they started getting all these complaints, they should have done it. And then that brings us to Mr. Watkins. Mr. Watkins is the email, and Mr. Odou tries to defend this by saying, oh, Judge, this was just about alkaline water in general. This wasn't about real water. This complaint is actually in a series of complaints between Real Water And Shani Castile, I can't remember who Pam and Karen are. Shani Castile was the production manager of Real Water at the time. So there's a series of complaints back and forth between Mrs. Watkins and the company, because these were home delivery people, and when the doctor said don't drink it anymore, they wanted to give the retail the dispenser back, and Real Water didn't want to give them a credit, and but so at the bottom it says, quote, "My husband has been in the hospital for 2 weeks, and the doctor wants him to start drinking alkaline water." All of that comes after all of this discussion about the 5-gallon home delivery and the dispensary. So, Mr. Odou can argue to the jury that this is just some general comment about alkaline water that he got. I think it's pretty clear what they were talking about. But this is, what more notice could you have than that a customer was drinking the water and went to the hospital? I mean, what more notice can you have? What was done with this complaint? Absolutely nothing. There was no investigation whatsoever, Your Honor. They didn't call Mr. Watkins. Mr. Watkins came to trial and testified. We anticipate he'll testify live again. They didn't call him. They didn't want to talk to his doctor. They didn't try to get the water. They didn't do anything. And so that customer complaint's admissible. Now, true, Mr. Watkins didn't find out that there was hydrazine in his water and say, oh, there's hydrazine. But that's not what we have to have. We have to have notice of a potential danger. Turning to some of the other, the written complaints, I think, and the email, really easy, okay? Those are admissible under the case law I've indicated. Mr. Odou says, well, Judge, this jury will be mad that all these people complained and we didn't do anything. Yeah, they will be mad because that's proof of conscious disregard. But the fact that it's potentially harmful evidence to him on the punitive finding, the yes or no, doesn't mean it's not admissible. Can I have the Beniti case, Shane? This is a case we cite in our brief. The probative value is not unweighed by the danger of prejudice because all of these complaints show that they had notice of the potential danger and they disregarded it. No investigation, no kind of testing of the water. They didn't shut it down like Mr. Destil said he would have done. Nothing is done. So I agree with Mr. Odou that the jury is going to find these complaints significant, but that's not a reason to preclude it. And then he says, well, Judge, we should admit these in phase 2, assuming that the jury finds punitive liability, not phase 1. Well, phase 1 is where they make the determination as to whether or not there was conscious disregard. That's where you've got to admit the prior complaints because that's the issue. You don't argue to the jury that there was conscious disregard and then go to the deterrence phase, I'm going to call it, and then argue, oh, well, look, here's evidence of conscious disregard. It comes into phase 1. So I didn't really understand that argument. Okay, the other people he mentioned by name, Kessler. Kessler wrote a written complaint. She's one of the 20 complaints. So we didn't want to just stop with that. We wanted to give a face to it for the jury. So we took her deposition and we played the part we designate, and we're designating this case as 13 to 15 minutes. And then we had two other customers that were subject to these complaints, Fisher and Dorn. Fisher was the airline pilot down in Tampa who bought the retail bottles from Sprouts, drank the retail bottles. This happened in, I think, 2018, exact same time period as Ms. Brody, who also drank retail bottles. So Fisher drinks it. He immediately has to be driven to the hospital, sick and ill. He makes a written complaint to him, tells him all this. Nothing. No investigation. Nothing. So we took Mr. Fisher's deposition so he could elaborate on it. We could get a face to this complaint. The third one is Doran, D-O-R-N, Susan Dorn. And she also wrote not one but 2 customer complaints. It's only counted as one among the 20. And she testified that she drank real water, and she was a big product champion, ironically. So she drank real water, and she was touting it to everyone, but it made her sick, made her dog sick. She sent in a complaint, or maybe it was a cat. I can't remember for sure. Remember. So one of her pets got sick. So she sends in a written complaint. She keeps drinking it, and a couple months later, her two elderly parents, one who had some kind of compromised immune system because she complained about that, they come to visit her from back east, and they drink the real water. The whole family gets sick. Everybody gets sick. She gets sick. The grandparents get sick. So she sends in another complaint to Real Water. Nothing done. No investigation. So we took her deposition to document this. So we have the 20 customer complaints. We have the 3 witnesses that wrote the actual complaints. We have Mr. Watkins and his email complaint. All those come in to show the conscious disregard because, again, nothing was done. The other testimony he referenced is Mr. Pham. Mr. Pham was in the quality assurance department. First, we had Patty Converse. She was their very first quality assurance director. She was hired to be a receptionist. 5 weeks later, they made her the quality assurance director. She's going to admit during her deposition she didn't have any qualifications. But anyway, she was the quality assurance director pretty much through the 2016-17 time period. Then she's followed by Mr. Desitel, who I've already talked about, Jeff Desitel. He's the quality assurance director for about 8 or 9 months. He gets fed up with the place and quits. And then they had the bad NSF audit I showed you part of yesterday on December 6, 2018. And then after that, they brought Mr. Pham in to clean things up, try to clean things up. So Mr. Pham was the 3rd quality assurance director in a row. So we've got the receptionist, Patty Converse, Mr. Desitel, and then Mr. Pham. So Mr. Pham starts either in late December 2018 or early January. I think it's more early January 2019. This is right in the time period prior to Mr. Hunwardsen's injury. So Mr. Pham starts working for a new company. You know, he testifies he drinks the water and gets sick. That was not an uncommon observation by the employees. But more importantly, he testifies that his neighbors, who I think we have referred to as Convey, he recommended Real Water to his neighbors, the people who live right next door to him, and said, hey, this is great stuff. I'm working for this company. You should go buy it. Where can we buy it at? We'll go to Whole Foods in Town Square. Directs them where to go. They go buy it. Mr. Pham is house sitting for them. He sees the bottles on the counter. Didn't testify he saw them drink the bottles, but he did testify that he recommended he saw the bottles. And then a couple weeks later, he testifies that on one day, he sees an ambulance come to the neighbor's house, take that neighbor away to the hospital. The very next day, a second ambulance came to the house, takes the wife to the hospital, both of which went to the hospital for acute liver failure. Now that's their best argument that there's hearsay here, because Mr. Pham, Dr. Pham, or Tom Pham is not a doctor, Your Honor, but his personal observations, what he saw, them drinking, the incident, those all come in. This happened, we think, in approximately June 2019. So this happened 3 months before the Hunwardsen liver transplant. And again, it's retail bottles, so we think that comes in also. I think I covered every one that they talked about, Your Honor. So anyway, the 20 written complaints we think come in for the reason I've indicated. The email is in the same boat. The testimony of Kessler, Fisher, and Doran and Watkins, which basically authenticates authenticates their complaint. That comes in, all notice of potential dangerous condition for the punitive case. FAM, Desitel, I think Mr. Odou forgot to mention one thing on Mr. Desitel. In addition to his dogs dying, his daughter had to have an emergency gallbladder surgery, which he also attributes to drinking the real water. So he testified to that as well, that her gallbladder was removed. So that's another part of the testimony that is covered in Mr. Odou's motion, but he didn't bring it up orally. So we think all that, and again, he's the former quality assurance director of Real Water that testifies if he'd known about these other 20 complaints, he would have stopped the presses, stopped the manufacturing process. Spend the time and energy, the $200 to do the test. So we think that's why all these are admissible, and the motion should be denied with regards to that. Thank you.
Sure. Court's got two questions.
Sorry, Your Honor.
I did not see, did Tom Pham actually complain?
Well, Tom
about his
Pham
name?
was.
His name. No, but
Did he file a written complaint?
Yeah. Is
No,
there anything that's
not that we
quote,
know about.
a customer complaint?
No, neither Tom Pham or his neighbors filed a written complaint that we know about.
Okay, thank you. Same thing with Desitil. I mean, I understand what their jobs were, but did Desitil file a complaint either for the dog or the daughter?
No, I do not think he filed a written complaint.
Okay, appreciate it. Thank you so very much. Counsel for Real Water, you get last word. Go ahead, please. I'm sorry, Terrible Herbst, did I give you an opportunity?
You
to-
did, Your Honor. It was a while ago.
Yeah, I'm just making sure. When you took the break, I wanted to make sure that you weren't contending that you needed some additional time.
No, Your Honor.
Okay, no worries. Go ahead then, final word.
Thank you, Your Honor. I guess I'll take it in reverse order. Tom Pham, page 52 of his deposition, did not know why his neighbors went to the hospital. So it's conjecture. They want to offer his speculation that it was because of Real Water. Tom Pham got fired from Real Water because he was using his employee time to arrange dates on some kind of dating app. And so clearly he's got some bias. If he's going to be called at trial, we'll raise that. Tom Pham, being in June of 2019, he's got to have some basis if he's going to offer a medical opinion in violation of Morsicato, and he doesn't even have that. Now, I agree. I missed the gallbladder testimony by Jeffrey Dosatel, who is Army, not Marines. I guess they get offended if you confuse that. And Mr. Desato is a very nice gentleman, but I don't think he would appreciate us confusing his service. And he did try to offer testimony about his daughter's gallbladder injury. We objected. It was admitted over our objection. Again, if a nurse in the Williams case and the Morsicato case can't offer that type of medical opinion, it certainly would appear to us that Mr. Desato can't offer a medical opinion that his daughter was injured because of the consumption of Real Water and had to have her gallbladder out. That seems like a medical opinion that should be out of bounds. It would be subsumed. I heard what the court said right before I came up, written complaints, and I think the court was trying to redirect the parties back to the focus of this motion, and I appreciate that. And that was the focus of this motion, was written complaints or claims. And so I apologize. We've kind of broadened it to cover multiple motions to try and save time. Plus, there's this distortion of time as to when did a complaint come in versus when did a plaintiff make an allegation. So let me stick to the topic at hand for a moment. Plaintiffs' counsel went through a number of cases which we distinguished in our reply brief. And what we distinguished about them is all of these cases that the plaintiffs relied upon are cases such as the box case or the motorcycle case, cases where you can see the instrumentality that caused the injury. And they say, well, that goes to notice. The liver injury is not something that you can see. Certainly you can have objective signs that somebody has a gastrointestinal issue. They've got vomiting, they've got diarrhea, they've got confusion. But to say that, oh, well, that automatically, if anybody says they've had vomiting from drinking Real Water, that automatically puts us on notice. No, it doesn't. In fact, Mr. Fisher, the airline pilot that was referred to by plaintiffs, had water toxicity. He was studying for his airline program, drank a lot of water and became sick, concluded it was because of Real Water. The problem with this conclusion is not supported by medical evidence, it's not supported by an expert opinion. The problem with all of these complaints is they're not supported by a medical opinion or any type of expert causation. And that's the first reason that we lumped them together and said they should be excluded. Certainly, if there was an expert for the plaintiffs that could have very easily said, I reviewed this 2014 complaint of this customer who consumed water or bought water from Terrible Herbst. They said they've got gas, oil, smell, whatever, and that is consistent with hydrazine. That would be a different story. We don't have that story here. Instead, we have the plaintiffs desiring for the jury to make that connection, and that is just improper. I guess lastly, I would just say that plaintiffs again talked about the $200 test that they're going to use for the punitive damages. It's not really before the court, but I felt like it shouldn't go unchallenged. Again, that is a test that no water manufacturer, not Nestle, not Coca-Cola, not Pepsi, normally does. That was admitted by plaintiff's expert. So yes, in hindsight, once somebody knows what they're looking for, they can create a test for hydrazine. In fact, that's what the FDA did here. After taking real water samples of concentrate from the factory, they went to a laboratory who had to create a special test to find hydrazine. They found hydrazine. That test cost $200. I know that's kind of a tangential issue, but I felt it was important for the court to at least have some background for that. So for all of the reasons that we actually talked about in the motions, we think they should be granted. We think these items should be ruled inadmissible. We recognize that the court does not have the deposition designations yet or the objections to those, so certainly if we need to parse those out, that would certainly be a reasonable accommodation.
Okay. Because challenge here is with your hearsay, right? You have a lot, what you're saying, they're hearsay. And counsels for plaintiff were saying for a non-hearsay purpose, right? For notices on a punitive damages claim. But how does the court have what the actual statements, right? Yes, you were correct where I was parsing out the way you phrased your motions, right? To preclude customer complaints,
Right.
Two different ones, because we're looking at 617 and 618, which are Real Water's motion limines 9 and 10, is how are you asking this court when I haven't heard certain testimony in certain contexts
Yeah.
to block out and preclude statements as hearsay versus having, if that testimony is sought to come in, do at the time of trial outside the presence of the jury, do, and try not to have too many offers approved little mini evidentiary hearings or something, but really address that at the time when we see what the case actually is going to trial, is actually going to be presented with what claims and defenses are still in the case, whether they be the exact same that they are today or whether they be different. There's no tea leaves there. It's just a matter of reality, practical reality. You want to address that
I
hearsay
do.
component, please?
Yeah, Your Honor, and I think that's an excellent point, and certainly Real Water would be happy to argue the issue. There's a trial demonstrative that the plaintiffs used in the last case. We've seen. Here we go. That's the one. We could certainly address it that way. It wasn't attached in opposition to this motion, to my knowledge. I didn't see it.
It was, part of it was contained actually in the text of the opposition rather than attached.
So, yeah, so then we do have at least the ones that they plan to offer. And we've certainly talked about that 2014 one. You can pull up the other ones. Is that not in 3, Your Honor, or 9?
Pardon?
Is that in plaintiff's opposition to 3? Oh, they did a joint opposition.
They did a
3
joint
and 9.
opposition. You all did a joint reply, which I realized that there was requests to do that, but you understand it does present some challenges sometimes when there's different concepts.
Judge, I filed a motion for approval.
That's what I said. There was, that's what I said. I fully realized I signed it. I said acknowledging that. It's just, I'm saying it presents a challenge. I think you have a right to do it, but it just doesn't mean it doesn't present a challenge.
So Your Honor, I appreciate that. I've got it in front of me, and I think we've already talked about it, so I'll try and be as brief as possible. Again, the issue becomes oily substance, whether or not that is hydrazine or not is complete speculation. The bottling machine that made the retail bottles also leaves an oily substance. If the bottling machine, the form machine that forms the plastic of the 1 liter bottles isn't fully cleaned. So again, for the plaintiffs to say, oh, well, that's from hydrazine is speculation, and that's where it becomes problematic. They say, oh, well, it goes to notice. Well, nobody had any idea, including the FDA, that there was hydrazine in the water. The FDA came up with a special test not done by water distributors to find the hydrazine and find the result of the problem. This was something, we called it a failure of imagination to even think of what could go wrong in the manufacturing process of the E2 concentrate that made the hydrazine. So again, to say, well, this puts, and maybe I'm arguing weight, but I still think this is prejudicial because they've taken every complaint and said, oh, well, the jury should assume it's hydrazine, or the burden shifts to real water to somehow prove that it's not, and that's not Nevada law. The burden is on the plaintiffs to show that these are admissible, and with the concession of liability as to the plaintiffs, and with the fact that the issue for Miriam Brody is medical causation, none of these are relevant. And then they go to, oh, well, it's relevant for conscious disregard, and again, they've got to put on some evidence, put on some way to authenticate these complaints and put them in front of somebody. And they say, oh, well, Jeffrey Dosatel, had he known about these complaints, would have stopped the line. Jeffrey Dosatel ran the production line. He ran the line where they filled the bottles. He didn't run the line, he wasn't the overall quality assurance supervisor. He wasn't the one to receive complaints. So they make a big deal. Oh, well, had he known about these complaints that were withheld from him, it wasn't even part of his job duties.
But is that, I'm stopping you for a quick second, because once again, I appreciate you all have the benefit of a prior trial, you have the benefit of breadth and depth of everything you're doing in a lot of the other cases. But for purposes of these 2 motions presented to the court, preclude customer complaints and evidence predating complaint, which is motion limiting number 9, motion limiting number 10 to preclude the pre-2018 customer complaints as hearsay, where are you asking the court broader? I mean, it seems like we're morphing into the concept of certain testimony that's not going to quote customer complaints. It's going to general hearsay concepts of what certain witnesses may or may not be able to testify to. You're saying it's within these motions? I'll address them because counsel for plaintiff argued it too.
Yeah.
But I didn't really see those broader concepts in the motions. And I appreciate when I referenced the chart, it was the chart that was handed to me yesterday that quote said other instances at the top, and it said 2020 outbreak cases was the right-hand column. And the left-hand portion is actually in the body of the joint opposition, and the outbreak cases is, I think, lower, I think a page farther down. So it's broken up into 2 documents. So it's before the court, but are these all customer complaints as articulated in your motion limiting number 9 and 10 that you're asking the court in these motions to address?
Yeah, you're right, Your Honor. The motions themselves are narrower and are directed at the written complaints, and we have different motions that talk about specific hearsay objections to specific people like Tom Pham. He's in motion limiting number 10, but some of these things do bleed over.
Okay, I'm just asking, do you want me to rule on 2 motions at a time, 3 motions at a time, 4? Because I appreciate there is some joint oppositions and some joint replies. I just need to know the scope of what you all are requesting. If everyone feels they've had the oral argument on it, I'll rule on more than 1 motion at a time. That's fine. I'll rule on as many as you want at a time, as long as everyone's on the same page and everyone's had an opportunity to be heard.
Yes, Your Honor. We would request the court rule on document 617, the joinders. I could read off the document numbers the court would like, our reply, and document 618.
Which your motion eliminates 9 and 10?
Yes, Your Honor.
Okay, here's the court's ruling with regards to that. Well, first, part of the court's ruling, and since parties have requested and have been able to argue the combination of these two motions, the court is ruling both on motion eliminating number 9 and motion eliminating number 10. With regards to motion eliminating number 9, to preclude the customer complaints and evidence predating the complaint, which is really the broader one, since the complaint would include everything predating it, including 2018, right, and earlier. Really what the court is inclined, well, what the court's going to order is as follows. The court is, first off, if there's not a, quote, written customer complaint or direct evidence that there was a verbal customer complaint, then the court has to grant the motion with regards to those, because those would not have been customer complaints. Or the notice concept with regards to punitive damages and would not be relevant to any other aspect of the case and would be something new in its characterization as a complaint for purposes of trial, which wouldn't be allowed. That would be similar, same analysis for motion eliminating number 10. Let's get to some specifics. To the extent that there is, let's go to the Watkins. Watkins has been characterized as a specific customer complaint with a hearsay component. The court is going to need to defer on the hearsay concept because I do not know who is going to testify with regards to that, what they're going to testify. While I have some excellent oral argument on a variety of different sides, right? I don't have anything directly before the court that the court can rule on that, on the hearsay aspect. And so therefore the court cannot rule on the hearsay. The court takes no position with regards to the other aspects that may or may not be met, depending on who appears or by stipulation or is addressed at the trial. With regards to the Kessler complaints, the court's going to say the same thing it just said with regards to the Watkins. Once again, we don't know who, if anyone's going to be testifying and what method, how they're going to be testifying. Is there going to be a stipulation, etc.? The court can't address the hearsay nature and for what purpose two documents in this case, right, since there's two complaints, may be sought, and I'm going to have to find out at the time of trial how they're sought, what they're sought, and if they're even being sought. So in order to make well-reasoned determination, I need to defer on that. With regards to Tom Phan, this is going to overlap. I appreciate something coming sooner. To the extent parties have conceded Tom Phan never filed a complaint on behalf of himself or his neighbors, then any aspect of him, quote, doing a complaint would not be appropriate to come in at the time of trial. And so that would be granted as precluded because that would fall under the first category that the court stated with regards to if there wasn't a complaint as of the time of your motion pleadings, then something could not come in for the first time at the time of trial. In addition to the other issues raised, which are going to be subject to a different motion, I'll deal with the other issues on the subsequent motion. Similarly, with Mr. Desitil, while branch of the military does matter, and we appreciate everyone for their service in every branch they do. I appreciate people do like to have the appropriate designation, but regardless of what branch of service he did, while we thank him for his service, he similarly, there's no complaints about either his dog or dogs or his daughter, then they can't come in as complaints. They can't come in for notice because they would not have existed and they would not have been presented as part of this case, and so they would not be able to come in. With the rest of the, quote, other instances that were set forth in the opposition that have been raised as far as a hearsay that were not specifically articulated in oral argument, the court's going to take the same position with all of those said documents from a hearsay component, because I would have to see who's coming in, how they're coming in, and for what aspect, and that's consistent with the court's prior ruling on pre-admission that, once again, we need to see if all the various standards are met, and so the court needs to defer on those documents. That should take care of Real Waters motion eliminating number 9 and Real Waters motion eliminating number 10. So the ruling is so ordered, granted in part, denied in part, and deferred in part. Okay.
Thank you, Your Honor.
It is the noon hour. It seems to me, unless you all want to incorporate your already oral arguments on Terrible Herbst motion eliminating number 10, then I'm going to pause for the lunch hour. If you just need a ruling on 10 and you think you all have exhausted your oral argument, then I will give you a ruling. But if you think you need oral argument, which is fine if you do, then we'll wait till that one till after lunch. Terrible Herbst, it's your motion. What's your thoughts? Talking about document 646.
Yeah,
ETN.
non-liver injuries from non-plaintiffs. We will incorporate the arguments, Your Honor.
So you just want a ruling from the court?
Yes, please.
Does everyone else agree? Does anyone want oral argument? If anyone wants oral argument, we'll wait till after lunch.
I'm fine with that, Your Honor. It's the same complaints.
We're ready to proceed and hear the court's ruling.
Okay. Well, for document 646, Terrible Herbst, motion eliminating number 10. Please see analysis the court just provided with regards to Real Waters, motion eliminating number 9, and Real Waters, motion eliminating number 10. Specifically here, you have a reference which is not limited to the type of complaint. So the first part of the analysis about the complaints would not apply. However, the rest of the analysis is consistent with not only the rulings today, but the rulings yesterday with regards to other individuals and setting forth the nature of their injuries other than the carve-out that we're going to need to talk about with regards to the notice component and how things may be presented as a response if there is a defense of not having hydrazine in the Terrible Herbst bottles, and the court's going to have to revisit what it's saying right now in part because we have to see what happens at the time of trial. But that would be granted in part consistent with the court's prior rulings, including most recent ones from 9 and 10 today. Here, though, the court would be specifically taking on directly because Tom found to extent that in addition to it not being a customer complaint, it would be this case based on what has been presented as undisputed with regards to Tom Fan not actually knowing what, well, he did see ambulances, did see bottles. Here, the court doesn't have any evidence from someone who would be competent to testify the nature of the injury or the reason for the ambulances leaving the respective neighbors' houses, the ambulances leaving the respective neighbor's house. So that would fall into this one to exclude the reference with regards to that because there is no relevant testimony that is even being through the offers mentioned in all the pleadings. And so that one would not just be subject to hearsay. That would be independently. It's already acknowledged what he's going to testify to and what he did or did not see. And so his speculative linkage between what did or did not happen would need to be precluded as non-liver related to non-plaintiffs. Similarly, the court's going to have to say that similar analysis with regards to Jeffrey Desautel's daughter, with regards to the gallbladder, because that has not been tied to the claims and defenses specifically. In this case, see all the court's prior analysis with regards to the other related motions. The court's not taking a position on Desautel's dog yet. I see that's coming up in a different motion. At that juncture, then it seems to me this is a wonderful time to take your lunch break. Have a great lunch break. Do you want to come back? What's best for you all? Do you want 1:15? How much time do you need depending on where you're going and what you're doing?
1:15 is fine, Your Honor.
Thank you, Your Honor. 1:15.
That's fine, Your Honor.
That works for everyone? Okay, we'll see you back at 1:15. Thank you so very much.
Thank you.
Thank you so much. Madam Court, clerk, go back on the record, please. Okay, welcome back after lunch hour. Same counsel, same parties, same case. So, maybe I should have done this one before lunch, but we'll go to document 653E, Terrible Herbst, motion limiting number 11 to exclude evidence of unrelated consumer complaints. Real Waters joined there 2722, plaintiffs joined opposition 857, and Terrible Herbst reply 950. Do you all wish additional oral argument, or do you wish me to incorporate the ruling on the preceding motions right before the lunch hour? Counsel for movement, let's hear your position.
On behalf of Terrible Herbst, we would incorporate the same arguments as prior to the lunch hour, Your Honor.
Joined a part of Real Water. Does that
We
mean
agree, Your Honor. Joul Odou for Real Water.
I just want to make one point that I forgot before.
okay? Then what I'm going to do is is everyone okay? Counsel for Plaintiff makes their point, and then I give both Real Water and Terrible Herbst an opportunity to respond. Does that meet everybody's needs?
Sure.
Okay, go ahead then, counsel.
And what I wanted to respond to is the hearsay comments, argument that Mr. Odou actually made in his reply. I believe that
Hold on a second. We've got somebody remotely who's not put themselves on mute. Please do so because we're engaging in oral argument, and all counsel and parties probably want to have a nice clean record. So please do put everybody else on mute, other than unmute it so that Mr. Kemp can be heard. Is this hearsay on 653, or are we going back to a different one?
it's on all of them because they're all the same. Anything that focuses on a written customer complaint and argues that it's hearsay, Your Honor. And pretty much every one of these motions makes that same argument. It is not hearsay because it's not offered for proof of the matter asserted therein. It's offered for notice, okay? It's a subtle distinction, but I've got the case we cite. Can you pop that up for me, Shane? This is the Beniti case. It's the Fourth Circuit opinion, and they're dealing with customer complaints in the, actually adverse event reports in the context of a pharmaceutical case. So on this exact point, this is what the court says. If it's going to the issue of notice, which is what they're going to, we're not trying to offer the proof of the matter asserted in the complaint. In other words, let's say a complaint says, okay, I drank real water and I got X, Y, or Z injury. We're not trying to offer to prove that that factual assertion is true. We're offering it as notice to the defendant of that allegation. Whether that allegation is true or not is immaterial, but it's notice to them, and that is notice of a potentially dangerous condition. So we don't get into this hearsay analysis. In other words, we don't have to bring in all the prior victims to say that they gave this complaint. We don't have to bring in doctors for all the prior victims saying that there was some sort of causation between Mr. Fisher vomiting and drinking of real water. All we have to prove is that the defendant got it, and they did get it because it came from their business records, and that they got the notice. So this argument being made that, oh, Judge, it's hearsay, there's no foundation. The only foundation that needs to be laid is that it's one of their business records, that they actually got it. That satisfies the hearsay rule because, and they do admit it's their business record. So since it's not being offered for the truth of the matter asserted, it's only being offered for notice. There's a different analysis here. And I think the very best case that I can allude to is that Guinness versus Mapes Hotel case. If the court remembers, that's one of the very first cases in the string of admitting prior incident cases. In Guinness, the issue was whether or not the door of this particular hotel, the doors for the hotel rooms were working right. And so they offered proof, a notice of a potential defect. The proof offered was 16 repair orders of other doors. Okay? They didn't even have a customer complaint. Okay, they didn't have a customer complaining. They had repair orders in their own records for other doors. Some of them were not even the exact same door as this particular door that was involved in the accident. So the court held in Guinness that in the strict liability context, remember, it's being offered for notice of a potential dangerous condition. They held that that was admissible. Okay. And there was no requirement that all the customers that came in that complained, if any, had to testify. There was no requirement that we had to bring in the janitor or the, I guess they call them engineers in the hotels now, hotel engineer to testify that in that particular accident this happened or prior repair this happened. All that happened, there were 16 prior orders, and those were deemed to be admissible because it's different than a negligence case. Okay, in a negligence case, when you introduce a prior incident, it's a different standard because it's not offered necessarily for notice. And, that the defendants have cited the El Dorado case, El Dorado versus Groff, and that case involved some lettuce that they had at the El Dorado Hotel in Henderson. And 6 months later, someone slipped on some lettuce in the restaurant allegedly. And so they held that was not admissible because it wasn't sufficiently similar. But that was under a negligence standard. When you have a case like this case, like Guinness versus Mapes, like the other incident cases, Beniti, and I think the classic example is the United States Supreme Court case we talked about, which was the one that Justice Stevens offered. In that case, they were determining whether or not to, again, that was another drug case. They were discussing admissibility of prior incidents reports, adverse events reports in the drug context. And the Supreme Court held that 20 years worth were admissible. They admitted 20 years worth of prior reports. And they didn't go through this, analysis of, okay, who wrote the complaint? Where's the doctor? What was the injury? Because it's all notice. It's just designed to be able, if the defendant saw this, if they saw these complaints about a gasoline-like substance, if they saw the complaint about oil, if they saw this, is that notice to them that potentially there was something wrong with the water that they should have done something about? That's why they're being admitted. That's why this argument that Mr. Odou made about hearsay is a little off base. So for those reasons, Your Honor, we don't think that there is a proper hearsay objection to these, the extent that they're just offered for notice, and they are. And with regards to his little side issue, the FDA did not develop a brand new test to test for hydrazine. This is a standard test that's been run since at least the 90s. Eurofins developed the test. In the Eurofins custodian records deposition, he testifies that they developed this special test. And I think it was because they had a rocket fuel leak up in Fallon at the air base up there. So they had a rocket fuel leak up there and potential groundwater contamination. That happened in the early 90s. That's where this test came from. Okay, that's the special hydrazine test that will tell you exactly the concentrate. That's not what I'm talking about when I'm talking about the $200 test. The $200 test is a test you could just run on water, and that just gives you a wide range of hundreds of substances that could potentially be detected by that. And Dr. Dooley is our expert on that. He's a toxicologist, so he'll be testifying on testing. And I agree with Mr. Odou. He's right. Normally that test isn't done in bottled water plants on a regular basis. But normally when they come up with a brand new product, which is what they did, especially through this rather unique manufacturing process, drop it through the titanium tubes twice and juice it. Our contention is they should have tested it in the first place. That's part of the punitive claim as well. But it's not some special test that the FDA developed just for this case. It's a test that's been used before. And so, Your Honor, with that, I don't have anything further to say.
Appreciate it, thank you. I'm going to let Terrible Herbst go first so that counsel sits, I'm going to let Real Water go first because you were the joinder party, and then Terrible Herbst gets final word. Go ahead, please.
Thank you, Your Honor. I'll be very brief. In the court's prior motion and limine rulings, I understood that other instances of hearsay were going to be evaluated later by this court, depending on what the purpose is being offered and to see the testimony. So I had understood the prior rulings of this court to already take care of the argument counsel just made, which is it'll be addressed on a case-by-case basis. There'll be an excerpt of the offered testimony of Mr. Fisher via video. We will make our objections, and the court will hear that on December 27th.
Judge, I don't think that's what the court said.
Actually, the court did. With regards to the preclusion, remember, this is generated from 9 and 10 of Real Water's motion to eliminate, and one of their arguments that these were hearsay. The court stated they needed to defer with regards to those motion to eliminate the argument that they would be hearsay because I do not have the actual documents in front of me. I do not have the documents how the intended purpose would be, nor the testimony that would even allow potentially introduction, even getting to foundation, et cetera. We don't even have stipulated exhibits or anything before this court. So I have to address all of that at the time of trial unless the parties have reached into some type of agreement beforehand. So I did do a deferral outside the presence of the jury with regards to the preclusion request of Real Water. So that part's correct. With regards to the $200 test, the court didn't find that issue was before the court because that was not part of these motions. I'm not saying it's not coming up. I'm not saying you all won't bring it up to me in some other context, but for those motions. So if that helps clarify things, I heard and understand everyone's arguments, but I wasn't precluding things. I was deferring it so that I could have the contextual information, testimony, et cetera, which would provide the potential foundation.
Judge, the customer complaints we provided an appendix in our opposition, and it's appendix number, I think, 1 through.
But you're not the movement.
I know, but you said it wasn't in the
specific, it's in a broader sense. And then remember the chart that was referenced, in which some of those attachments that you're referencing are phrased under other instances, some are under customer complaints, and so it made it better, more well-reasoned determination that I defer because they're the movement, they're seeking to preclude. There's not a complete scope of what exactly they're seeking to preclude. And so I have to look at how this motion came before me. It wasn't plaintiff's affirmative motion.
In Your Honor, I don't want to mislead the court that there's going to be testimony on these complaints because the only three that there's testimony on is Kessler, Doran, and Fisher. The others, the only testimony would be from Real Water that they're their business records, which I think they've admitted already.
But, well, at this juncture, I do not have any stipulation. Once again, that's why I made the comment about I appreciate you all contextually have done another trial, are doing depositions, all sorts of things in multiple cases. But remember, I have to take the procedural posture of this case before this court where it is currently. I don't have any stipulation admission of exhibits. I don't have all of whatever method it is going to be sought to be introduced. It's maybe a better way of saying it, whether it be by testimony, et cetera, which is why the court needs to defer, realizing that these are Real Water motions to preclude, and that's why I said I'm deferring. I'm not taking an affirmative position of inclusion or preclusion. I'm deferring.
Understood.
Okay, thank you.
I
Councilor,
don't think I have anything to add. I think we're going to have to work it out in the scope of the order. And I think I understand what the plaintiffs are saying and what the court is saying, so I don't have anything to add. As far as the video depositions that will be played, that's not before the court yet. That will also be another way that this could be addressed if there's still a dispute.
okay. So, clarity, I'm going to give Terrible Herbst an opportunity to speak, and then I'm just going to say that these are treated for all the motions that you all have asked me to deal with, starting with document 617, motion eliminating number 9, through document 6, so it'd be document 617, document 618, 646, and 653, which is Real Waters, motions eliminating number 9 and 10, and Terrible Herbst, motion eliminating number 10 and 11. Counsel for Terrible Herbst, do you wish to be heard on what was in response to anything from plaintiffs or not?
Just a minor point. I understand Your Honor's ruling and we'll agree with that. We just point out that the notice issue, that doesn't apply to Terrible Herbs in our opinion because those complaints weren't made to Terrible Herbs and they're not our business records.
Which is part of what I need to hear right at purposes of partly at the time of trial, right?
Exactly.
I don't know if somebody's going to come in by whatever method. When I say term come in, I don't know if it's going to be deposition, live, assertion from a document, et cetera, that you actually did, which is part of the reason why I can't rule. I can't rule it on the notice concept because I don't even have that basic foundation, which is why this court was saying I needed to know all the other bases first before we really get to all of that, which is why I had to defer. Okay, so the court's ruling on Terrible Herbst's motion eliminating number 11, which was document 653, is consistent with the court's prior analysis and by agreeing with the parties that it be treated similar to Real Water's motion eliminating 9 and 10 and Terrible Herbst's motion eliminating number 10. The court gave its analysis and same granted in part, denied in part, deferred in part, consistent with those prior rulings. That takes care of motion eliminating number 11, document 653. It is so ordered. Now I need to ask you all whether or not you want the court to treat document 616, Real Water's motion eliminating number 8, 613, Real Water's motion eliminating number 5, 681, Terrible Herbst's motion eliminating number 12, and 671, Terrible Herbst's motion eliminating number 14. Excuse me. Sorry, those first three is what I meant to say, not the last one.
Right.
If you wish the court to treat those in a group or separately, and I will tell you, I'll give you, so do you want them as a group or separately? Because they're really, I'm going to ask you all, why isn't there just NRS 50, right? And 51, what lay witnesses can say, what experts can say, and please follow the applicable statutory provisions in case law, but let me hear if you want them combined into 3 or one by one. Counsel for Real Water and Terrible Herbst are going to ask you all because you're the movement. So Real Water, you're the movement in the first two, so
Certainly we can do 616 and 672 together. I didn't hear, and apologize if we were trying to do Doc 613
yeah, I'm sorry.
as
Yeah.
well.
Document 616, Real Water's motion eliminating number 8, limit lay testimony. Document 613, Real Water's motion eliminating number 5 to preclude lay witnesses from providing medical opinions. Document 681, which was Terrible Herbst's motion eliminating number 12 to exclude medical causation opinions by lay witnesses. If you wish the court to deal with them separately, together, or any different combination, the court's gonna be fine with any of them. I just need to know how you would like it so that we can address it.
Together is fine, Your Honor.
That would be fine, together, Your Honor.
Counsels for plaintiff, are you fine having them together?
Yes, Your Honor.
Okay, so here's the court's inclination. The court's inclination is please follow the law. There's specific case law with regards to what lay witnesses can testify to, both statutory and case law. With regards to what, quote, lay witnesses providing medical opinions, you all know there's also the same case law with the carve-out to the extent if there's a carve-out of a treating provider can provide certain expert-like opinions because if they're designated as a treating provider, whether that applies with some of the Brody aspects or possibly Hunwardsen, that may or may not apply, so the court would say, see the applicable statutes, NRCP provisions, and case law that set forth what lay witnesses can testify to, the carve-out if it's a treating physician with regards to medical causation and medical type opinions, and that's where the court was inclined to go. So, counsel for Real Water, let's get to yours. Go ahead.
Thank you, Your Honor. Thank you. I appreciate Joul Odou on behalf of Real Water. Appreciate the court's ruling. I'm going to inclination. So I'm going to address things that are outside of the court's inclination and reserve time to respond if there's argument on the court's inclination that I need to address. In particular, I'm going to talk about the Edge case, which is Patty Converse. We sought to exclude her not only for hearsay reasons, but because because of hearsay reasons. And her case is a little different because she doesn't have personal knowledge. Our argument for her is found on page 10 of our reply. And there's a series of questions that the plaintiffs wanted to ask her about things that she had no knowledge of, such as the fact that she was not part of the concentrate making process. And the plaintiffs want to imply that there's something suspicious because the room is locked and she's not allowed in there. In fact, that was the testimony we sought to exclude. They also want to go through and say, well, she's the quality assurance director, so how can she do quality control when she's not making the E2 concentrate? Well, she's not the quality control person for the E2 concentrate. All concentrate was made by Blaine Jones, who was at the time a vice president and an officer of the company. There's nothing nefarious about her not being involved in the concentrate process because the concentrate wasn't made every day. It was made to go for as many days as the bottling needed, and then they would make more, and only Blaine Jones would make more, is the testimony. They also seek to introduce evidence of OSHA violations. OSHA violations have nothing to do with hydrazine. Her testimony that there were OSHA violations, particularly they relate to the floor being wet, slippery, plugs being too close to water sources, that kind of thing. It's just a smear. It has nothing to do with hydrazine in this case. They also talk about the audit and the fact that the audit had an electronic signature that she doesn't recognize, therefore, it must be forged. Again, not really relevant. Maybe we can address that at the time if the audit comes in to evidence, but we had objected to it just to make sure there's no waiver. I think really the court has addressed, I'm just scrolling through to make sure there wasn't anything else that I wanted to address. Sorry.
Mr. Destol's dog is mentioned in this one as well.
Yeah, Mr. Destol's dog we've already talked about. I think that, it's hearsay and it's not probative of anything other than what happened to the poor dog. We've talked about Mr. Destol's daughter, and I think that's already been covered. I'm certainly happy to readdress those things, but in the interest of time, I think that covers everything just looking through our motion.
Okay. Part of why my inclination didn't go to Ms. Converse is I was trying to put the rubric of the objection is lay testimony, but it seems that Converse is that it's more like an absent of knowledge, or speculation. And so I was trying to see how it was in the lay context versus a different concept.
And the reason why we put it in this context is that they were trying to, use her to provide expert opinions, because an expert could an expert can offer an opinion based on things that other employees had told them. So in Mrs. Converse's case, she at several times says, well, I heard this, I heard that from other employees. And she can't do that as a lay witness. An expert can do that, but she cannot do that. And that's why it fell under this particular rubric. In particular, she wants to talk about how the concentrate was made, or I wasn't allowed to go in there. Doesn't matter. She doesn't have personal knowledge of how the concentrate was made. The fact, the mere, well, let me take a step back. We don't know if Ms. Converse is going to be here live and in person or via video. Last time she was in video, and so it was easy for us to address, specific objections because we have the designations. Certainly, if the court wants to defer ruling and see her when she comes or when she is unavailable because we're unable to get her to appear, that would be another acceptable and fairly expeditious way to handle this.
Thank you so very much. Appreciate it. Okay, Terrible Herbst, you did a joinder to some of these, and then one of them is yours as well. Go ahead, please.
Just briefly, Your Honor, and then I'll reserve time to address any comments by plaintiff's counsel. I think the lay witness testimony on causation is particularly prejudicial to Terrible Herbst, and I think we just need to follow the rules and follow the law. And so we would ask that any causation opinions from any lay witnesses be precluded. Thank you.
Did you want to go into any of the specifics that were set forth in your motion that have not otherwise been addressed by real water that you want the court to take into account versus the general concept?
No, Your Honor, I think we addressed a lot of the specific individuals. I think there's the dog issue is the same. Mr. Pham, we've talked about extensively in his neighbors. So,
Okay, thank you. Counsel for plaintiffs, I'm going to ask you just a question, just to let you know. Mine was a general statement, follow the law, that's easy, right?
Right, Your Honor. Then
But are we to
you saw
have
what happened.
depots? Yeah. Are we having depots or live testimony on these various individuals, or do we know yet?
Hattie Converse lives here in town. Last time we tried to serve a subpoena and the process server wasn't successful in serving the subpoena, we wanted her live. We sent him out there 3 or 4 times and we couldn't serve a subpoena on her. I'm not saying she was intentionally trying to evade the subpoena, but we couldn't get her live last time.
Okay.
So we have done depot designations for her that we're filing today. So I don't know if we're going to be able to get her live or not, but I'm thinking it'll probably be by depot.
Okay.
If it's by depot, I think these things can be handled in the depot objections and the like. Because there's just so many areas that they're raising. This is really not a lay expert. That they're saying she can't say that she was barred from the concentrate room. Well, she's the quality assurance director. How can you implement any type of HACCP program if you don't even know the materials being used to make the product? And every single person that's testified about HACCP, every person, Mr. Pham, Converse, our expert HUD, has said, Hedel, you have to know what's going into this product to follow it through the chain of production. And so the quality control director is locked out of the HACCP room, the concentrate room. And I would agree, she doesn't know how it was made because she was locked out of there. But that's the point, that she was locked out of there and they didn't tell her what materials were going into it. So we should be allowed to do that. That is nowhere near expert testimony. That is her personal observation that she was locked out of the room and she wasn't told what materials were being made. On the OSHA issue, we have agreed not to admit OSHA citations because what happened is OSHA came in there and cited them for a lot of things, some of which are not germane really to the case. But that was the whole reason they made her quality assurance director, because she was the receptionist for 5 weeks. OSHA came in there and zapped them, and so they had to have someone respond to it. So boom, she's the quality assurance director. But some of the OSHA citations, like water spilling, pooling on the floor next to electrical outlets, those are observations that she actually saw. The communications back and forth between her and OSHA, we aren't trying to get in, except maybe they would be used to refresh someone's recollection. But just to say that anything pertaining to OSHA is out, I don't think that's appropriate. Now, with regards to the forgery, she testified, remember we have this NSF audit, so Costco's got NSF going in there. They're supposed to be going in there every year. So I can't remember if it was the 15 or the 16, but she's the quality assurance director, and they put her name on this NSF audit to sign off as the quality assurance director. She testified at deposition, and it really came out of nowhere. No one really asked her that question because who would expect this? But she looked at the NSF document and said, "That's not my signature. Someone forged it." Okay, now Mr. Odou says all of a sudden that it's an electronic signature. I've seen no evidence of that. And that question wasn't asked her at the deposition. But think about that for a minute, Your Honor. The auditor comes in, the NSF auditor. She's the quality assurance director. She's the primary contact for that auditor. He has a written report that he submits to the facility to get corrective action. And someone forges the quality assurance director's signature on that? I mean, that is not expert testimony. That is fact witness testimony. Now, moving on to the last one they admitted to, they said, "Oh, dogs, no one can talk about dogs. Ha, 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 there's no causation." Well, in the Southern Nevada Health District report, they specifically documented 3 different cases of dogs that were being fed real water and dying. 3 different cases. So the Southern Nevada Health District thought it was relevant. We think there's an argument here that it's relevant. I'm not going to belabor the point because it's not the most important testimony in the world, but it is clearly relevant. Mr. Pham, I think we've talked about him plenty. Addressing the court's first question on Mrs. Converse. Pham apparently lives here, lives in San Francisco, and lives here, and lives in San Francisco, because we also had a process server out there. We're trying to get him to come live to the last trial, and we were not successful. So I don't know if Mr. Odou knows something I don't know, because he brought up some new facts today I'd never heard before, that he was fired for doing online dating while at work or whatever it was. So I don't know whether Pham is going to be here live or by deposition. I would expect it's going to be by deposition. But if the Whole Foods aspect of it is not admissible, and I understand that to be the court's ruling, referring to the neighbors situation,
Right.
if the neighbors is out, Pham will be more limited and directed in pretty much pure HACCP, which we could probably do by deposition, I would think. And I think I've covered all the points, Your Honor. But I think the basic problem I have is you can't just throw out a rule saying, okay, lay's good, expert bad, because it's all in the eye of the beholder. And let me give you one concrete example. Mr. Watkins, for example. Their position is Mr. Watkins can't testify to the jury about his injuries, that he was vomiting, that he was dizzy, that he went to the hospital, because he's not a medical doctor. That's lay testimony. That's their position, Your Honor. Their position is I have to bring in his doctor to show that he went to the hospital for acute liver failure. I don't think that is the rule. I think a lay witness can testify as to his own personal the impact a substance had on him or the condition he was in. That's his own perception. So now if that witness was going to talk about someone else's injury, like the Pham situation that you've already excluded, I think they have a better argument that Mr. Watkins can't talk about what happened to himself. But that's why I think a broad brush rule here isn't going to, it's just going to lead to more arguments later. And we're going to have to go case by case, which I think Your Honor already has kind of foreshadowed.
So let's analysis. Conclusion. Else, can you point me to the reference that you had for Watkins vomiting with regards to these motions? Or was that just a generalized example?
That's just a general,
Okay.
yeah, that was just a description of his symptomology. But basically, we just jumped to it and say he's an acute case.
Because what the challenge partly with these are is there's correct statements of the law in the motions, right? The replies then give some specifics, but there really isn't the detail that allows this court to give what I'm hearing you, counsel, asking this court to do, because it's not been presented to me, right? There's been Ms. Converse, yes. Bristol, yes. There's some specifics there, right? But that's why I asked you about.
Remember, this isn't my motion, Your Honor. I'm not asking you to do anything.
Oh, right, no. Right, but since you're saying that giving the generalized concept of follow the law, right? Because oftentimes these generalized motions of lay witnesses are follow the law, you know. People don't have specifics here. The court was looking for specifics so that the court could articulate a ruling that would be particularized to this actual case. But I can't do so if they're not in the pleadings. So that's why addressing Driscoll with the dog and the daughter, you have for this motion, right? I'm not saying that they're not references in other motions that aren't brought under this context, and I've ruled on all the ones I have so far, right? So
Right. And even,
I'm hearing what you're saying, but how can a court give specified?
I don't think you can, Your Honor, which is why I think the motion should be denied. You've given the general rule that it should be denied, and then when we get to Converse, either her designations or her live testimony, and we get to Pham, either his designations or his live testimony, it's going to have to be fleshed out on a point-by-point basis.
Okay, I've heard, thank you so much for your position. Since we have both Real Water and Terrible Herbst, which order do you all want to do your final words? Who wants to go? Okay, go ahead.
Your Honor, in the case of Joul Odou for Real Water, in the case of Steve Watkins, we do have the document. We saw it a little bit earlier today. It was an email basically saying, the doctor told me.
It's the wife's email.
The
It's not
wife's
even his-
email,
it's not his
excuse
email,
me.
yeah.
The wife's email, the doctor told her husband not to drink alkaline water. Mr. Watkins' testimony, I believe it was that he later learned that Real Water made him sick. So to use it for notice as to when it was sent, really, it's problematic. And it's problematic in the sense of the diagnosis and discovery and the connection as to when he learned should be in his lawsuit. He's a plaintiff. He's going to have his day in court. He's going to be able to tell a jury about his injuries. They're seeking to admit his injuries in this case.
But not in these motions. Sorry, folks, I got to keep focusing on, right?
Okay.
Is
Then
what's the
we'll-
rubric I'm looking at for each of these motions, right? I appreciate, and I understand why you all, or, you know, you're dealing with this at a macro level, but this court has to, right, under the applicable law, look at these at a more micro level, which only means motion by motion, or if you all wish to consolidate motions, have the court hear things together, I can do that, but I can't conceptualize something that's not in some pleading that then makes it before this court, because you can appreciate where that would go from a slippery slope, right? Then people could throw all sorts of things, right? And as you
You're right,
know, the
Your Honor.
appellate courts say, right, if it's not before the court, then the court can't rule on it, can't give advisory opinions. If it's not before the court, at the lower court, then oftentimes, not always, the appellate courts don't take it up. So I'm trying to be very careful to make sure what's actually before me I'm ruling on versus what I understand from everybody's experience in dealing with another case and all the other cases you're dealing with is you have insights of things that you think might happen, but if it's not before this court concretely, I can't give advisory opinions, won't give advisory opinions, and don't give advisory opinions.
I appreciate that, Your Honor. I was drawn into the argument and
I know you
couldn't
all
help
are.
I apologize.
No, it's not a matter. I mean, I like I said, you understand.
I do.
I understand where everyone's coming from, and if I'm not going to say, you know, but
It's-
I did
it's-
litigate before I became on the bench. But the role as a judge is different. But the appellate courts tell us that we need to focus on what's actually before us, not more global concepts. Which is why I keep for everybody trying to get you focused back into the actual motion or motions before me. So in yours, you had a couple of examples, right?
Yes.
Is there any other examples that you wish the court to address concretely versus the more global concept, which, like I said, I understand it means there's going to be some rulings during the trial, but realistically, those rulings are going to need to happen because it make a difference if you have depot excerpts, which you have a chance to object to, and then the court's going to rule on that, right, question by question. That's going to be one avenue. Others is going to be witnesses come in live, unless it's specifically precluded, I may have to be doing question by question, dealing with appropriate objections. So that's part of my job.
The court's points are well taken. We attorneys hear the ice cream truck and we immediately go running, and we got drawn into the argument. I
No
apologize.
worries. They've got some good ice cream sandwiches and other things going on in ice cream trucks. So, okay.
So the only other point, very briefly, and I hear what the court's saying, is the Patty Converse issue. The other piece of that issue that we pointed out in our reply brief is she left Joul Odou in 2017. The first plaintiff in this case is 2018. So what happened before is of very little relevance. Certainly there may be some relevance, but not a whole lot. That's it.
Okay, let's go back to Converse. You actually said both of them, both Converse and
Bam.
I was going to say Driscoll. You
Desitel.
said Desitel. You said they both were not there 2018 forward, which means as far as the actual plaintiffs in this case, they wouldn't have knowledge as to the specific plaintiffs in the case, and plaintiffs respond and say they're on for the notice concept. So, and you all said it more eloquently. I'm just cutting to the chase here. Okay.
Court's got it. No, that's right.
With regards to your preclusion on a lay witness, an NRS 50 argument, is there something you're asking the court to consider, or just a pure time period makes things post a particular date you're saying means it's
The court is correct as to the hearsay and the specific arguments. We had, for the completion of the record, also argued the 2018 departure of those employees, and I was just merely making sure that we had set a record. Probably belt and suspenders are overkill because we're going to have to revisit this issue, but I hear what the court's saying and have nothing further to add, actually.
okay. Counsel for Terrible Herbst, go ahead, please.
I have nothing further, Your Honor.
Okay. Does anybody say that there's specific examples before this court on these three motions other than Dissidel and Converse, specifically in the pleadings, that the court should be addressing specifically as to an individual rather than the concepts presented in the motions? If so, let me know. Hearing silence, silence, and silence. Okay.
No.
So then the court does have to adopt its inclination. I'm in no way saying that I'm not going to address these question by question. Particularly, I may be doing some of them if you're doing depot designations, right? Which will give everyone an opportunity if somebody's coming in via depot to actually have more of the, let's use ice cream trucks, right? To know whether it's a bomb pop, a popsicle, right? A sandwich, fudgesicle, or whatever it may be. And if I've skipped somebody's favorite push-up, whatever. If I skip somebody's favorite ice cream, my apologies, but those are the ones I'm aware of that go on ice cream trucks, so it's been a while. Okay, so the court's inclination gets turned into a ruling. It is so ordered for purposes of our wonderful clerk and court recorder to translate what I just said. That means that court was saying to the extent any of these motions is asking for something outside of applicable statutes, rules, or case law, it would be denied. To the extent they're asking all parties to follow appropriate statutes, case laws, and rules, then it would be granted. With regards to specifics of the couple of examples that were phrased in at least one of the motions, because it's unclear at this juncture with regards to Converse issue becoming in live versus deposition, the court would need to defer to have an understanding of what she is actually going to try and say to see if she has the appropriate background to be able to know whether these are firsthand perceptions within NRS 50 or if she's trying to go into NRS 51. Similarly, same thing with Mr. Dissidel, the same statement. Nothing in the court's ruling on these motions is in any way intended to be inconsistent with prior court's rulings. Okay, well, that shows we are, it is so ordered, through what we thought we were going to get through today. We do seem to have extra time.